in my presentation because we're gonna go back to this because this was a case that I recently assisted with on behalf of the employer. The employer initiated the termination on their own and then sought my assistance afterwards. And so in this particular contract, Mr. H had this entitlement. So he was going to get a base salary, and he was also going to be entitled to an annual bonus. And basically the bonus was 10% of the overall profitability within the Ontario region, right? There's really no discretion in that, right? If the company is profitable within the Ontario region, he's to get 10%. So that is the it's fixed. Now, it says here as well as the bonus is awarded annually and paid 60 days post year end. So at the end of this provision, they've indicated here that the employee must be actively employed at the time of the bonus payment to receive this bonus. So in my employer's mind, if Mr. H is not actively employed by the 60 days following that time period, then he's not to get the bonus that would have otherwise been paid to him. Okay, we'll carry on to the next. Okay, so why does the distinction matter between discretionary bonuses versus non-discretionary? So under the Employment Standards Act, vacation pay is calculated on wages. Okay, under the Employment Standards Act, wages include amounts that are non-discretionary. So if you have a truly non-discretionary bonus, similar to what we just saw in Mr. H's contract, then any amounts payable to that employee on those non-discretionary amounts should also incorporate vacation. Now, we know under the Employment Standards Act that there are minimum vacation rates that are payable to employees. So for the first 5 years, it's at the rate of 4% and thereafter 6%. And that's required. You must pay the applicable rate of vacation on any wages, including non-discretionary amounts. If you pay your employee more than that, though, you have the ability as an employer to, so let's just say that the person is entitled to 8 weeks of paid vacation. Not 8 weeks, but 8% vacation for 4 weeks of vacation per year. That would otherwise be an 8% on any discretionary bonuses. You can, as an employer, in a contract, limit the amount of vacation paid on the non-discretionary amounts by including a term in the contract regarding that. So although they, for general purposes of vacation, they're entitled to 4 weeks or 8% vacation pay, for the purposes of the bonus, it will only be the minimums under the Employment Standards Act. So that's something to be mindful of. So if we go into the next slide, if we go back one, or sorry, is this the, okay, so talking about vacation pay, right? If you are paying out a non-discretionary amount, similar to Mr. H's agreement, if you don't pay that, the employee has the ability to go to the Ministry of Labor and request an order that the employer comply and pay out that outstanding vacation. What employers really need to know is that any claim for unpaid wages or vacation pay, the employee has 2 years from the date that the wages are due to make a claim for vacation pay. So if you have not been paying vacation pay on the non-discretionary bonuses, think about how many employees do we have? How much would that be over a 2-year period? What is the exposure? So there's a potential that when you proceed with a termination, and if we go to the next slide, this is what happened. In this situation where I was assisting the employer, we received a demand letter back regarding the notice that the employer had provided. And first of all, in that demand, he obviously made a demand on the annual bonus that was that he had. This gentleman was terminated in early January. He made a claim for the bonus of the 2024 bonus, And because of the statutory notice period of being actively employed, because you're deemed to continue to be actively employed during the statutory notice period, that 2024 bonus was payable. So although in the notice letter, they had indicated to him that on a without prejudice basis, they're going to pay it to Mr. H. I had to advise the employer, well, no, it's not on a without prejudice basis. He is entitled to it because it would have been payable during the Employment Standards Act notice period. Then what the council on the other side recognized is that in 2023, as well as the bonus that was going to be paid for 2024, because bonuses are paid in February of the following year, they were going back to the bonuses that were paid in 2023 and 2024 for the prior 2 years. Mr. H had these large bonus amounts that were paid to him based on the same formula, 10% of profitability, so no discretion. And they demanded that he be paid vacation on those bonus amounts at the rate of the vacation that he was entitled to receive. So unbeknownst to the employer, when they proceeded with the termination, that they now had an employee coming back and asking to be paid the vacation. So it's about an $8,500 an amount that was going to be paid to him. So when I'm advising the employer, this was a new client to me. When I'm advising the employer of yes, they are correct on this, now they have to internally really look at what's the overall liability that we have for all of our other employees who, unbeknownst to them, may be are probably entitled to backdated vacation pay. So that's something that we're going to be working out, and whether or not they need to maybe update their bonus scheme to make it more of a discretionary situation. But that's a big concern for them. So going forward as well. So bonus entitlements upon termination. First of all, you need to ensure whether or not to ensure that the contract that you have with an employee has an enforceable ESA only provision. So is the employee on a contract that limits them only to the statutory notice period, or can they argue that they're entitled to a longer period of notice, which we call the common law reasonable notice period? Under the Employment Standards Act, all entitlements and benefits must continue during the statutory notice period. So like Mr. H's situation, although the employer thought they could say on a without prejudice basis, that amount of the bonus he was entitled to receive it because the payment date was within that period of time. Now, if there is no ESA only termination provision, we have to think about what the reasonable notice period is. And do all entitlements and benefits continue during that common law reasonable notice period? Go on to the next. Okay, so the basic starting point, like we had said before, if there is no enforceable ESA only provision, the employee is entitled to receive anything that they would have received had they been able to work out the reasonable notice period. So the courts assume that an employee is going to, when an employer terminates an employee, that the employee should get working notice, but not a lot of employers do working notice. So in the alternative, the court will say, okay, what would they have received had they been given that opportunity to work out that reasonable notice period? So we'll go on to the next. Here is the position that employers will typically take related to bonus payments and entitlements during the notice period. They will say to be entitled to a bonus payment, the employee needs to be actively employed at the time the bonus is paid. Okay. What the Court of Appeal has said is that they've confirmed that non-discretionary bonuses that would be reasonably anticipated by the employee and have been provided in the past, so on regular increments and in regular amounts, are considered integral to the employment contract and will be included in the calculation of damages. So for Mr. H, he had historically received large sums of compensation through the non-discretionary bonus. And because he was not on a provision in the contract that limited him only to the Employment Standards Act minimums, we had to consider then what would be entitled, how much of the bonus he would be entitled to during the reasonable notice period. And so my client had initially had said, but he has to be actively employed, right? What, you just told me that at least the ASA period has to be there, but beyond that, he's not actively employed. The courts have said, the Court of Appeal has said that the term that requires active employment when a bonus is paid without more is not sufficient to deprive the employee of the bonus amounts that they would have otherwise received during the notice period. So you have to be very specific, not just active employment. You have to be very specific regarding the waiver of any additional bonus payments during a common law notice period. Okay. So in advising my client, I had to say to them, if you had allowed him to work out the notice period, would he have been able to receive a payment? Now, in this case, in this case, the employee had only been there for 8 years. So typically at most, we were looking at an 8-month notice period. Because he was terminated in January, he wouldn't have been actively employed until the end of the 2025 year, right? This is the employer's position in order to receive any amount for the 2025 year. But let's go on to the next slide. Okay, bonus payment date, right? So you have to be actively employed on the date of payment. And again, the employer's position in this situation was to be entitled to that, the payment date must fall within that 8-month notice period. However, we've had a recent case from the Court of Appeal, Andrews versus Colliers, confirmed that when an annual bonus is an integral part of the compensation package and is completely non-discretionary, so in Mr. H's case is if there's any profit, you get 10% of it. The employee is entitled to a proportionate amount of that bonus, even if the bonus is paid after the common law notice period. So in this situation, the other side relied upon this case, and in my view, based on the circumstances of Mr. H, where his bonus was equivalent to between 25 to 40% of his annual income, was always paid, was completely non-discretionary, they did have the ability to seek a prorated amount of that bonus during that 8-month notice period. So in the Court of Appeal case, what the court said is, absent clear language in the contract, I do not accept the inherent unfairness that would arise in precluding those employments terminated without cause by seeking a prorated share of their business only by virtue of the fact that the notice period ended before the bonus payment date, particularly when the bonus payment date is entirely in the discretion of the employer, right? So in Mr. H's case, they had already indicated the date in which it would be paid, but because this was such a large sum, it was historically given, and because of the non-discretionary aspect, in my view, they were right to be able to go and say and rely upon Andros to say that a prorated amount for the notice period should be provided. If you go on to the next slide. Okay, so we also have another recent case that provided us basically with how do we calculate the prorated amount. And when we have a situation like Mr. H, the Court of Appeal has basically said, let's look at the last 3 years, we'll average it, and we'll use that monthly average for the reasonable notice period. Okay, so going on. Again, Mr. H, he was terminated mid-January, 8 years of service. Again, just by saying you have to be actively employed does not waive the entitlement. So the 2024 bonus that he had already earned was payable. It was not going to be paid out to him on a without prejudice basis. And there was no references to damages for the bonus during the notice period. So going forward, we ultimately ended up having to settle for the notice period with a prorated amount of the bonus during that period of time. We can go forward on slide. Again, the reasons for that is because of the integral overall compensation that this bonus represented. Every year the company had profit, it was always paid, and the employer then, unfortunately I had to say to them that you're looking at an additional $37,000 plus vacation pay on that amount as a result of the terms in the contract that you had with Mr. H. So, lessons learned. Analyze your bonus scheme. Is it truly discretionary or is it non-discretionary? If it's non-discretionary, have you been not paying out vacation pay on it? What is the overall liability? In Mr. H's situation, the liability could have been reduced a little bit on vacation pay had the employer put a term in the contract to limit the vacation pay payable to the lower ESA rate. How many other employees will this affect? It was very important for my client to have a really strong confidentiality term in the settlement because they don't want Mr. H telling other employees about this potential 2 years of vacation pay. And they need this employer needs to do something about that going forward. Maybe adjusting their bonus scheme to be more discretionary versus non-discretionary. The other lesson learned for the employer was they have to protect against the additional damages during the notice period. So we have to be able to clearly contract out of any prorated amount. We have to contract out of any amount of damages during the notice period that goes above and beyond the ESA only. And we have to ensure that the act of employment is specifically limited to the Employment Standards Act statutory period only. So I believe that's it. If anyone has any questions, happy to hear.
No questions have come through the chat, but thank you, Meagan, for sharing this. I know it's a lot of information, but it's definitely one of those hot topics I definitely had to consult my clients on. So thank you very much. And yeah, if there's questions, let us know in the chat box. I will switch gears. I just wanted to talk to you before we wrap up about some of our events that are coming up. So we have our next slide. So we have our HR Hot Topics. Our event is sold out, so thank you those who have registered. The registration is officially closed, but if you would like to be placed on a wait list, you can email Gowlings and I will put the email in the chat box right now. Okay, should come through. And then we're also excited to host our first H2R Executive Networking group event at Lala Social House on Wednesday, April 2nd from 4 to 6. We designed this event for business owners, CEOs, and business leaders to connect over drinks and great conversation. No speeches, no sales pitches, just meaningful networking. So I will share the registration link in the chat again. And a big thanks to all of our sponsors. We're very grateful. And lastly, we are facilitating a workshop on generations in the workplace on April 2nd as well. This time it runs from 9 a.m. to noon. It's at the Cambridge Chamber of Commerce, and Danielle Hunter, our senior HR consultant, is the main facilitator. Spaces are very limited, so if you would like to register, please send an email to info@yourh2r.com and you will be registered. So that concludes our lunch and learn. Just a quick question I see. I think this one's from Meagan. If we pay out a bonus at 10 years, 15 years, 20 years, specifically for a work anniversary trip, would this be considered a discretionary or non-discretionary bonus?
So gifts, like this seems to be a gift in reward of tenure. These are under the Employment Standards Act, there are some exceptions, and this would probably fall with under the discretionary, such that there is no vacation pay payable on that.
Okay, excellent. Again, if there's other questions, feel free to drop them in and we will address them. I know we're 2 minutes past 1, so we will conclude and we'll see you next month in March. Thanks again for your participation. Bye for now.